So I have an update for you in the California concealed carry ban challenges, which seek to strike down and overturn the state of California's new ban on concealed carry. So let's talk about what is happening. Now, really quick before we jump into this video, I want to thank one of the new sponsors of the channel, which is Brownells. I love Brownells. I got to meet a lot of them over at a recent event when we went out to Iowa. We did an event there, some speaking engagements and all that, and I got to know the guys better, and I've known a lot of them for a long time, but just got to tour their facility, see what they do. They're an amazing company. They're pro 2A. They believe in the 2A fight. And so if you guys are interested, check out Brownells. I can't give you any links or anything like that, but check them out. And if you use the code SCHOLAR10, you can get 10% off of your order. Now, as I mentioned in the intro, in this video, I have an important update for everyone in California who are currently facing the state of California's attempt to ban concealed carry statewide. The Ninth Circuit recently issued their decision on whether they will in fact overturn the preliminary injunction, which is currently in place against all of SB 2. The Ninth Circuit decided that the carry bans that are currently in places like hospitals, churches, medical facilities, public transportation, and then also the catch-all private property bans, all of those are in fact invalid, that they violate the Second Amendment. But the Ninth Circuit panel also found that the state of California and their carry ban in places like bars and restaurants that serve alcohol, playgrounds, parks, state parks, casinos, stadiums, libraries, zoos, museums, and all parking areas attached to those locations were in fact okay, that they did not violate the Second Amendment, and therefore they upheld those aspects of SB 2. So this was a very mixed decision from the Ninth Circuit, which has now led multiple plaintiffs in these consolidated lawsuits to now seek en banc panel review in the Ninth Circuit. So they appealed that Ninth Circuit decision up to the next level of the Ninth Circuit. Both in the Hawaii case and now one of the California challenges, there have been appeals up to the Ninth Circuit en banc panel. And one of those cases, in fact, is one of the cases that I'm a plaintiff in along with Reno May. In that case, we're going to be talking about is the May versus Bonta case. Now, if you're not aware, in that case, Reno May, myself, and other plaintiffs joined along with CRPA and also Gun Owners of California to sue the state of California because of their new SB 2 law. On review of this case, the federal district court judge, Judge Cormac Carney, granted a preliminary injunction against various aspects of California's new CCW restrictions. That preliminary injunction against SB 2 was appealed then up to the Ninth Circuit and was then consolidated with other cases, one of the FPC lawsuits, and then also the Hawaii Wolford case, which has now also been appealed up to the Ninth Circuit en banc panel. In our case, we received a preliminary injunction halting the enforcement of California's carry ban, at least until the case was decided on the merits by Judge Cormac Carney. But as we all knew, the state of California was not going to go quiet, so they appealed up to the Ninth Circuit. They also filed for an emergency stay of that preliminary injunction. The motions panel in the Ninth Circuit originally did grant an administrative stay, but then the merits panel that reviewed this case did remove that stay. That meant as we sat before the Ninth Circuit decision, all of SB 2 was blocked, and the concealed carry laws remained the same as if they were the same before SB 2 was even passed. But now we have that new decision from the Ninth Circuit, which upheld some aspects of SB 2 and reversed some of the language from the lower court. This, of course, has huge ramifications for concealed carry permit holders in California, and that's why it's now being appealed. Like I mentioned, the Ninth Circuit in their decision struck down some parts of the carry ban, but upheld some others. Now, in coming to their conclusion, the Ninth Circuit actually used a looser version of the Bruin analysis. The Ninth Circuit stated that, "We conclude that the proper approach for determining whether a place is sensitive is as follows. For places that have existed since the founding, it suffices for a defendant to identify historical regulations similar in number and time frame to the regulations that the Supreme Court cited as justification for designating other places as sensitive. For places that are newer, defendant must point to regulations that are analogous to the regulations cited by the court, taking into account that it is illogical to expect a government to regulate a place before it existed in its modern form. For both types of places, historical regulations need not be a close match to the challenged law. They need only evidence a principle underpinning our nation's historical tradition of regulating firearms in places relevantly similar to those covered by the challenged law." The Ninth Circuit used this looser historical approach, this looser Bruin analysis, to uphold some of these sensitive location bans, but even the loose approach still did not find enough historical justification to completely ban concealed carry in places like churches and then every single private business. Now, when it came to the catch-all vampire rule, the Ninth Circuit found that Hawaii's law, which was also part of some of these cases that were challenged, they found that the Hawaii law varied enough from the California law, and therefore they upheld the Hawaii law, the catch-all phrase, the vampire rule in Hawaii, but they said California's was different and they struck down California's. The court found that since Hawaii's law allowed businesses to allow carry by posting a sign, but also through writing and oral consent, it was not a violation of the Second Amendment. But in contrast, since California's law only allows permission through posting a sign, they found that that was too restrictive and did not have historical support. Now, this of course opens up some possibilities and also some concerns that I expressed in my original video, that California could now simply have a playbook to modify their laws to try to mirror what Hawaii did and what the Ninth Circuit found would not violate the Second Amendment. So all California had to do was change some of their laws, and then their vampire rule would be upheld by the Ninth Circuit, which is concerning to say the least. Now, when it came to specific bans like places on worship, the Ninth Circuit found that those locations clearly existed at the time of our founding, and they could not find a single historical law or analog that would support a state outright banning carry at those locations. That shows that even though the court is using a looser approach when it comes to Bruin in that analysis, the Bruin analysis is still so strong that even a looser Bruin approach still cannot find enough justification for these types of outright bans at places of worship and then also the catch-all provisions. Now, after that decision, there were some questions about what would some of these plaintiffs in these consolidated cases do. Since this was a mixed bag decision, in some of these consolidated cases, there were some wins and some losses. There were questions on whether or not they would in fact try to seek en banc panel review. In my last video, I mentioned that there was probably no doubt in my mind that the Hawaii Wolford case would in fact go en banc for review because that is one of the biggest losses. Unfortunately, everybody in Hawaii got the biggest loss because the Ninth Circuit upheld the catch-all vampire rule in Hawaii and then also a lot of the other provisions. So that one was a little bit of a no-brainer to go to the en banc panel. And now that case has been filed for en banc panel review, but also the California May v. Bonta case is seeking en banc panel review. Now, keep in mind, all of these cases are still in an interlocutory process. They're still interlocutory appeals, the reviews of preliminary injunctions. And even if these cases eventually make their way out of the Ninth Circuit en banc panel and eventually maybe seek Supreme Court review, there is no guarantee the Supreme Court would grant review because the Supreme Court does not like preliminary injunctions. However, I do understand that there is a strong need to appeal right now, especially when you look at plaintiffs like those out of Hawaii who are facing a complete carry ban. You cannot have that language sit and affect the Hawaii laws. And then also allowing that language to stand opens up risk for states like California and others to simply modify and mirror what Hawaii did, try to pass those, change their laws, and then that would sit as precedent. And the Ninth Circuit and other courts, even lower courts that want to rule pro 2A, would have that language sitting there as precedent that they would have to follow. So now en banc panel appeals have been filed and we will see ultimately what happens. I also anticipate there will be requests for stays from the Ninth Circuit en banc panel to stay the Ninth Circuit's decision to keep all of SB2 halted because you don't want a hodgepodge mix and match approach when it comes to SB2 being enforced because that would be super confusing for states like California and Hawaii. So I anticipate that that will be sought for the en banc panel to grant. And then hopefully the Ninth Circuit en banc panel grants the stay and all of SB2 remains halt while these appeals are taking place. And also we're going to be hoping for a favorable draw from the Ninth Circuit because if you're not aware, the Ninth Circuit en banc panel operates through a randomly selected 10 judges that are selected and then the 11th judge is the chief judge. So hopefully we get a favorable pro 2A panel that will find that SB2 is in fact unconstitutional. So that's what's happening in California and Hawaii with the concealed carry bans. As we get more information, I will let you guys know. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.